The case entitled In Re Green Mountain Dog Camp LLC, case number 24 AP 317. Appellant Janine Mannanen is self-represented and is not present for oral argument. Representing the appellees, Jane Henry and Casimir Vikatis, is attorney Heather Devine. Present with attorney Devine is Ron Shems.
All right, good morning, Ms. Devine. The appellant has not appeared. If you have something that you'd like to add, you may do so, or you may rest on your brief.
If I may, I would like to say a few words.
Please proceed.
Thank you. So my name is Heather Devine. I'm representing interested persons, Casimir Vikatis and Jean Henry. Appellant's argument seems to be that she's adopted mitigation measures that make the impacts of her dog camp less bad.
Your audio is dropping in and out.
Okay.
So I think you need to stay up close to your mic.
Okay. Can you hear me okay now?
Yes.
Okay. Appellant's argument seems to be that she's adopted mitigation measures that make the impacts of her dog camp less bad. This misses the point and it muddles what ought to be a straightforward analysis. We're here under Act 250 Rule 34E, the Stowe Club Highlands analysis. The analysis under Rule 34E and an Act 250 permitting analysis are different. Under Rule 34E, if an applicant wants to amend a permit and amend a condition critical to the issuance of the permit, the appellant must show that the need for flexibility outweighs the need for finality. And only if she's made that showing would we go on to consider the possible impacts of the proposed project under the Act 250 criteria. Appellant hasn't made that showing here, and that ends the analysis. There's no factor under Rule 34E that favors flexibility, and there are two factors that strongly favor finality. It's clear that the District Commission, when issuing the permit, reasonably relied on the strict wildlife protections, and it's clear from uncontested testimony that neighbors reasonably relied on those protections in purchasing their properties. An appellant hasn't contested those facts. It's also clear that appellant is seeking to relitigate the permit. Her arguments on appeal are arguments to relitigate the permit. She's arguing that the original permit's protections aren't necessary and that her dog camp's impacts aren't that bad. That is a relitigation of the permit. Appellant clear-cut significant portion of deer wintering habitat on her property. She installed a dog camp in the former habitat and right next to continuing deer wintering habitat. And then she asked for a permit amendment to approve what she'd already done. The District Commission and the Environmental Division appropriately and correctly concluded that Rule 34E barred her claim, and respectfully, we ask this court to do the same. Are there any questions?
Seeing none, thank you, counsel, for your argument. Bailiff, please call the conclusion of this case.
Next hearing for the court is scheduled for 9:45 this morning.